Certain issues caught my attention over the week. First, the issue that relates to Joint Admission and Matriculation Board (JAMB) and what I call the overnight resolution of the crisis at the House of Representatives. So these issues will be our focus on the program today. Welcome to Law Weekly on Channels Television. I'm Victoria Ido. But before we go on, let's take some legal stories.
Five senators, led by Senator Kabiru Marafa, who had approached the court seeking an interim injunction to stop the setting up of Senate standing committees on the ground that the election which produced the Senate president and his deputy was illegal, since the Senate never amended the Senate standing rules of the year 2011. The lawmakers told the court that it was urgent to restrain the defendant because if allowed to go ahead with the setting up of the committees, they will appoint their supporters, disenfranchising the others. However, Justice Gabriel Kolawole declined the application, saying the court was not created to supervise the internal affairs of the National Assembly, except if in the conduct of its internal affairs there is an infraction of the Constitution. He warned that when the National Assembly has misapplied its own rules, the court must be wary in intervening. It should even be more wary when the intervention is sought as an ex parte. Justice Kolawole held that the Senate Standing Order 2015, as amended, has no substantial infraction on the 1999 Constitution to warrant court's intervention. He thereafter refused the application and ordered the plaintiffs to put on notice the defendants in the suit, which include the Senate President, the Deputy Senate President, the Clerk of the National Assembly, the Clerk of the Senate, and the Senate itself. A federal high court again declined to stop the Speaker, Right Honorable Yakubu Dogara, from appointing principal officers and standing committees for the House of Representatives. Justice Gabriel Kolawole, while ruling on an ex parte motion brought by Honorable Abubakar Lado and Olanipe Kunjimo seeking to stop the Speaker from appointing principal officers, held that the issue is a domestic affair of the House of Representatives. Justice Kolawole said that the court can only intervene when there is substantial infraction of the 1999 Constitution, and that for now there has been no breach of the 1999 Constitution. He added that it's not the duty of the court to choose principal officers for the National Assembly because it had its own machinery. Accordingly, the court will not allow itself to be used as a platform by aggrieved members over what they should canvass on the floor of the House. The court, he adds, is not a supervising institution for the National Assembly on account of separation of powers, and that there is no evidence before the court that the Constitution has been breached. He therefore refused the application in its entirety. Justice Kolawole thereafter directed that the defendant in the substantive suit, which include the Speaker of the House of Representatives, his deputy, the Clerk of the House, and the Clerk of the National Assembly, be put on notice and served with the originating summer. The case has been adjourned to August 12 before Justice Adeniyi Ademola. The Rivers State Governorship Election Petition Tribunal sitting in Abuja has dismissed the motion filed by Governor Nyesom Wike challenging the power of the tribunal to sit in Abuja instead of Port Harcourt, the state capital. The tribunal, headed by Justice Muazu Bindiga, ruled that the motion by the governor and his party, the People's Democratic Party, lacked merit and substance. Governor Wike and his party had filed an application challenging the powers of the President of the Court of Appeal to allow the tribunal to sit in Abuja instead of the state where the election in dispute was conducted, claiming that the sitting of the tribunal in Abuja was in breach of Section 285, subsection 2 of the 1999 Constitution and provisions of the Electoral Act 2010. However, in his ruling, Justice Bindiga held that the tribunal has not violated any provision of the law since the relocation to Abuja was based on security reasons. He disagreed with the claim by the governor on proximity and accessibility as the two major factors that ought to have determined the venue of the sitting. adding that proximity and accessibility cannot be determined in the absence of security of the tribunal members and litigants. Justice Pindiga also said the President of the Appeal Court acted within the ambit of the law, which laid emphasis on ensuring a conducive atmosphere for the tribunal to hold proceedings before it can be set up. Meanwhile, the Rivers State Governorship Election Petition Tribunal sitting in Abuja has refused to strike out the petition filed by the All Progressive Congress and its governorship candidate, Mr. Dakuku Peterside, because his party failed to notify INEC of his candidacy in due time. Chairman of the tribunal, Justice Muazu Pindiga, also wrote that the tribunal was duly constituted by the President of the Court of Appeal and is competent to hear the petition. Governor Nyesom Wike and the Independent National Electoral Commission had filed separate application challenging the constitution of the panel and the authenticity of the petition filed by the governorship candidate of the All Progressives Congress on the ground that his emergence did not follow due process. They had also asked the tribunal to disqualify itself on the grounds that it wasn't duly constituted. The sitting has been adjourned till July 31 for ruling on the constitutionality of a pre-trial hearing. The APC in Rivers State and its candidate in the April 11 governorship election, Peterside Dakuku, dragged INEC, PDP and the governor of the state, Nyesom Wike, before the tribunal to challenge his victory at the election.